Today, the state trial regarding Oregon's gun control measure, that's 114, got underway out in Harney County. We're going to dive deep into this issue as well as little pieces of the trial that you're not going to see or read about almost anywhere else. To make sure that we're all on the same page, Measure 114 requires people to get a permit before buying a gun. And to get that permit, they have to go through a criminal background check and a gun safety course. The measure also bans what it calls high-capacity magazines, which hold more than 10 rounds of ammo. Measure 114 has already been found constitutional in federal court, so that means it does pass the muster of the U.S. Constitution, according to one judge. But this state trial is the reason the measure has not been implemented since voters narrowly approved it last November. And here's the big issue that is going to be answered by the circuit court judge in Harney County. Is Measure 114 constitutional as it applies to the Oregon Constitution? Here's the exact wording of the state's constitution that's being considered. It's Article 1, Section 27, if you want to look it up yourself. Right to bear arms, military subordinate to civil power. The people shall have the right to bear arms for the defense of themselves and the state, but the military shall be kept in strict subordination to the civil power. That's it. Pretty simple, huh? The judge has already said that he plans to rule only on the language of the measure itself when it comes to how it applies to the state constitution. He will not make a ruling based on how the measure could be implemented in the future. And that is a big deal because there are still plenty of questions on how this could play out if it's found constitutional. But that does not matter this week. It's all about language this week. The trial is scheduled to last 6 days, though the judge said it may not go that long because he restricted certain testimony, again, to only focus on the language. Today, the judge heard opening arguments, and the plaintiffs, those are the people who want to throw 114 out, they called witnesses. They also get tomorrow to do that as well. Then the defense, that's the state, will call witnesses Wednesday and Thursday. Friday and Monday are the extra days in the case the testimony runs long. But before opening statements could even get underway today, there was a moment in court that we think is pretty important to highlight. It shows that even though these are incredibly heated, partisan, tough issues, we're all human.
I received your trial memorandums on the 13th and 15th. I'll be frank, I haven't had a chance to really process everything that's in them. I've looked over each of them, but haven't had time to really process all the information. It's a lot of pages, and it was my daughter's birthday this weekend, so turns out that takes priority.
Well, there you go. That's right. Each side submitted memorandums or outlines of their cases late last week, but the judge had his daughter's birthday to focus on. Anyway, let's get to some of the opening arguments, starting with the plaintiffs, the people who do not want 114 to take effect.
Plaintiffs will show that Article 1, Section 27 of the Oregon Constitution protects the individual Oregonians' right to bear arms in defense of themselves and the state. Article 1, Section 27 was ratified as part of Oregon's original Constitution on November 9, 1857. 164 years, 364 days later, on November 8, 2022, ballot measure 114 was passed. Plaintiffs contend that ballot measure 114 represents the most significant threat to that right Oregonians have faced in nearly 165 years. Your Honor, this case is not about public health, public safety, or public concern. This is about individual rights. This is about the individual right to self-defense and the right to bear arms to secure that right. This case is about how an individual right will fare against the might of the Oregon state government. Plaintiffs contend that this question was answered 165 years ago.
All right, so there you have it from the plaintiffs. Now let's hear from the attorney representing the state, hoping that they can implement Measure 114.
Evidence in this trial will demonstrate that Measure 114 was a reasonable legislative response to the public safety concerns posed by firearms. The testimony of defendants' experts will demonstrate to the court that large capacity magazines increase the number of firearm homicides and the frequency and fatality of mass shootings. That large capacity magazines were not in common use for self-defense in the 1850s. That modern firearms bearing large capacity magazines do not have any relevant 1850s counterparts, that large capacity magazines are rarely used in self-defense, that the permit to purchase is a reasonable public safety measure, and that any time restrictions contained within it are consistent with the historic exercise of the right to bear arms. At the close of testimony, Your Honor, we will ask that you find Measure 114 is constitutional under Article 1, Section 27 of the Oregon Constitution.
Now, following those opening arguments, the plaintiffs called witnesses. And one of those witnesses included a man named Derek LeBlanc. He's a firearms instructor who owns his own training company. Before the state cross-examined LeBlanc, the trial was delayed so the plaintiffs' attorneys could show text messages between himself and LeBlanc. The state was trying to show that LeBlanc is actually a gun advocate and not an independent expert. They cited a blog post that LeBlanc wrote during the federal trial on Measure 114. Take a listen.
You said here that you planned to help our attorneys. Is that true?
I think you're taking words out of context and you're trying to use them against me. And that's not the point of this blog post. This blog post is to educate gun owners to understand, what we're all up against with Measure 114.
And did you do work to help the federal attorneys?
No.
But it says here that you were working to help our attorneys, and you testified earlier that it was the federal attorneys that you were helping.
Well,
correct?
the way I look at it is I'm on a team, and it's my team against the other team, just like you're on the opposite team of me right now.
Interesting, don't you think? The state attorney then asked LeBlanc if the plaintiff's attorney had told him about the questions that he would ask him during today's trial.
Did Mr. Aiello tell you that the 11-page document outlined the answers that he was looking to get in your testimony today?
Can you repeat that, please?
Sure. Did the 11-page document that Mr. Aiello sent you outline the answers that he was looking to get from your testimony today?
Well, we were, that was part of our conversation. We were just kind of spellbound. This is my first time here on the stand in this regard. And so I'm ultimately scared. I'm just an average guy that I was just looking for what this looks like, right? So I could wrap my mind around what I needed to do to prepare.
Did the 11-page document that Mr. Aiello sent you outline the answers that he was looking to get from you?
No.
Ouch. So the state attorney submitted a document as a court exhibit and then asked LeBlanc to read part of the second page.
On the third line, did Mr. Aiello write to you, "I've outlined the answers I'm looking to get"?
It's there, yes.
This is what you call taking apart an expert witness. The next part of the questioning from the state was having LeBlanc confirm that he previously pleaded guilty to 2 counts of contempt of court in Lane County earlier this year in an unrelated case. Quite the cross-examination on day one. We'll see what tomorrow brings out in Harney County.